Hello, I'm Dan Beaton, a member of NEPC's Defined Contribution Consulting team, coming to you from our Boston office. And thank you for joining us today for a webinar on DC litigation, where we will highlight a recent trend with forfeiture account lawsuits that have been an influx as of late, even as late as last week. And for today's conversation, I'm joined by Jenny Eller from Groom Law Group. Jenny is a principal with Groom's Fiduciary and Retirement Services practice. She works closely with large corporate and public plan sponsors on ERISA compliance. So this is an area where she has a lot of expertise, and we're going to lean on her today to walk through this very nuanced topic, which can get dry, but Jenny will bring this to life for us, and we'll leave you with some considerations on how you as a plan sponsor can review and perhaps even improve your governance around forfeiture accounts. Before I get into it, though, we want to just point out that we do have a few slides for today. They're up on the screen. We also have a handout tab where if you want to download those, you can. We always get that question, and you can load those now as we go through. This should be about 40 minutes or so. Hopefully, we can have some interactive questions from the group here. I'll monitor the chat function and see if there are questions from the crowd and give those to Jenny as we go through. But I want to leave you with, not just education on the topic, but also give you some areas where you can take away and perhaps improve your governance on it. So with all that said, let's get into the beginning of just an overview on what forfeiture accounts are, very easy to say there for me, and how they are traditionally used in a DC plan. So let me turn it over to Jenny.
Thank you. Thanks, Dan, and thanks everybody for taking the time to be with us today. So if we want to go to the agenda slide, we can, at a broad level, we're going to talk just a little bit about what forfeitures are and how they can be used. And then, many people have probably heard about the spate of lawsuits over the last year. It's really, there's been quite a few of them. So we're going to talk a little bit about why they're happening, what the allegations are, what the defenses are. And then, as Dan said, really at the end of the day, what people want to know is, what should I be doing? What can I do differently? How could I insulate myself and my plan from this kind of action? So with that, let's go to the next slide. And yes, please do post your questions as we go along if you have them. So again, very high level, what are forfeitures? And when you think about it, we all know our plans probably have a forfeitures account. And what's the reason for that? Well, qualified plans are allowed to have a vesting schedule. You don't have to vest every participant in the money that the employer contributes or matches to the plan immediately. So, for example, many plans will have a 3-year vesting requirement for employer contributions. After a participant meets that 3 years or whatever the vesting requirement is, then those contributions are non-forfeitable, meaning if I leave the plan, I can take them with me. They are part of my account and they're allocated to my account. But what if I don't stay for 3 years? I don't meet the vesting requirement. I leave the plan. Then there are dollars in the plan that are the result of employer contributions and they have been forfeited. And so they are unallocated amounts sitting in the plan's trust. Let's go to the next slide and talk a little bit about how we can use forfeitures. And it's a pretty interesting question. You would think that this would be more well settled than it is. Certainly the Internal Revenue Code allows forfeitures to be used to reduce employer contributions. And when you think about it, from a policy standpoint, that makes sense, right? The employer already contributed this money to the plan. The plan is allowed to have a vesting schedule. And so the idea that you use money that is in the plan to reduce employer contributions that go to another employee or are spread across other employees makes sense from a policy standpoint. We want employers to contribute to plans. But if you can never get the money back, then you might as well, or get the use of the money, then you might as well say you're not allowed to have a vesting schedule. Congress certainly, in the legislative history of ERISA and some of the updates, talked about using forfeitures without requiring that there be any particular priority about how you use them. And then many of you probably know is in 2023, the IRS proposed regulations around the use of forfeitures. So there's some guidance out there. They're only proposed. And they really built off older IRS guidance that was pretty informal that essentially said, in order to have a qualified plan, somebody has to be able to know what their benefit is. It has to be definitely determinable. And so part of the thinking on that is you have to eventually allocate all of the money in the plan. You just can't have money sitting around unallocated. So let's talk then about, this is what the tax code says, what Congress says, what do people do with forfeitures, and how do we think of them? We can move on, I think, to the next slide. And I give a lot of fiduciary training, fiduciary updates, and one of the things I always say is when you have assets that are sitting in the plan's trust, they can be used for two purposes and two purposes only: to pay benefits and to pay the reasonable expenses of administering the plan. You can't pay for another plan's benefits. You can't give the money to charity. That's really all you can use plan assets for. So we know that that's the general rule around plan assets. And we know that forfeitures are plan assets. And we know that because they're sitting inside the plan's trust. And once money goes into the plan's trust, it's an asset of the plan. So it does make you think, well, we know that we often use forfeitures for other things. Like why is that okay? Let's go to the next slide and talk about that a little bit. So I sort of think of forfeitures as a unique category. And we talked about kind of the policy reason for that, right? They're plan dollars, they're in the plan's trust, but they are amounts that the employer has contributed. And the policy and the tax code indicate that they can be used for sort of a second try at employer contributions. So we do think of forfeitures as having a unique status. And while they are plan assets, one of the things, we've been asked as these cases that we'll talk about in a minute have kind of come out is, well, we know what the IRS thinks about forfeitures. What does the Labor Department think about forfeitures? And we have a very few things to go on. And most of it is sort of in the form of non-objection guidance. But there was actually a lawsuit that the Labor Department brought against a plan sponsor. It started from an investigation in 2017 where the Labor Department looked at the plan terms, and the plan terms said forfeitures have to be used first to reduce plan expenses before they can be used for any other purpose. And in that case, that particular plan did not follow the terms of the plan and used forfeitures for other things. So that's the one case that DOL has ever brought. And you think about the Labor Department investigates plans all the time. The Labor Department issues guidance all the time. You would think that if DOL thought, we don't really care what the IRS says, you can't use forfeitures to offset employer contributions, they might have mentioned that somewhere along the way, right? But the only case where they've actually brought an enforcement action is really distinguishable in the sense that they made the argument. It ultimately was sort of settled, but that really what was happening is the employer wasn't following the terms of the plan. The only two other pieces of guidance that are, kind of a little bit relevant is an old advisory opinion where the question really was about preemption. What does ERISA preempt? And does it preempt if a plan escheats money to the state? And there DOL said, well, they gave an answer on the preemption question, but part of the question had to do with forfeitures. What if we have forfeitures, we can't find the person? Can we escheat that money to the state? And DOL said, as long as the plan terms say that you can do that, they made a call on the preemption. But again, if they thought that it was a problem to use forfeitures for something other than plan expenses, you'd think they would have mentioned it. And clearly the department talked about what does the plan say. And then finally, a little bit more recently, in the context of mutual fund settlements, the department, again, in a field assistance bulletin said, forfeitures shouldn't be used to offset employer contributions unless the plan terms allow and the Internal Revenue Code, is okay with it. So, same sort of thing there. The department had the opportunity to say, gee, you have a fiduciary problem if you use forfeitures in various ways, but they did not. They didn't take the opportunity. They didn't say that. So that's a little bit of the background of what forfeitures are, what they can be used for, what the IRS thinks and what the DOL thinks. And so, with all of that background, we were all sort of going along our merry way. Dan was going to committee meetings. I was going to committee meetings. Everybody's talking about, Secure 2.0 and all the things we need to do to keep our plans safe from litigation, et cetera. And lo and behold, plaintiffs firms came up with a new and novel theory. And that has resulted in about 20 cases filed in the last year. So let's talk a little bit about the forfeiture cases that have been filed. I want to make sure people know about them. Dan, I don't know if it's something that you've talked with your clients about or has come up in committee meetings, but I do think it's an area where we're certainly seeing a lot of interest.
Yeah, I think you outlined it great that regulatory agencies have really kind of had a process, and it was understood by most clients for years, and now recently started to question, okay, what is the blind spot that these plaintiffs' attorneys are trying to exploit? So I think as you walk through the litigation here, that could be helpful to learn.
Right. Okay, so the first thing I want to do is kind of give a timeline. On the next slide, there's a kind of a timeline of what we've seen. So this 2017 case that I just talked about that really didn't end until 2022 is where the Labor Department brought suit against a sponsor for violating the terms of the plan. And then we really didn't see much, right, until September, November 2023. There were a handful, about 5 cases that were filed all in various federal courts in California. As people probably know, ERISA empowers plan participants in certain cases, other fiduciaries, the Secretary of Labor, to bring lawsuits under ERISA to enforce the terms of the plan, and to ensure that violations of ERISA are addressed, especially where there's a loss to the plan. So we saw 5 cases filed in the space of a couple of months, all by one firm that is located in California. The cases were filed in federal court in California, all by the same firm. And there was certainly, a lot of press and interest in those cases. And then, we had a little bit of a lull while things sort of worked through and people answered and submitted motions to dismiss and all that sort of thing. And then, early in 2024, we saw another 5 cases, mostly in California, 1 in New Jersey, 1 in Virginia, and now we're up to 3 firms. So starting to see it grow. In May of 2024, the first decision came down. As people may know, often complaints are filed, and then the defense has an opportunity to file a motion to dismiss, to essentially say to the court, taking all the facts that are alleged as true as a matter of law, the allegations here don't rise to the level of a fiduciary breach, a violation of ERISA. The very first decision on a motion to dismiss came down in May of 2024. And in that case, the plaintiffs won that motion. They didn't win the case. It's still ongoing, but they won the motion. The court said, no, we're not going to dismiss this case. We think the plaintiffs have made, enough, their allegations have raised enough questions that we're not going to dismiss the complaint. So that was in 2024. And then between June and November, the last one was just filed last week. We've seen another 15 cases. They've been filed in a dozen jurisdictions by 9 law firms, including in situations where, where there's sort of these forfeiture allegations are being added on to other types of litigation, the more standard fee and performance litigation that we see so often in ERISA these days.
So, Jenny, maybe if you don't mind, can you touch on the different jurisdictions, how much of a role that will play, or does it play in a case getting dismissed or moving forward? I assume it's somewhat based on where the sponsors are located, but is that no accident on the plaintiff's bar to try in a lot of different venues?
Right. So the rule is that you can bring the case where the defendant is located, where the plaintiffs are located, and most of these companies that are being sued are, very large, have presence everywhere. And there is some degree of, of forum shopping. And I think in this case, the plaintiffs' attorneys were trying to figure out where there might be some kind of helpful, where courts might be particularly helpful, say in the Ninth Circuit. Those might well be courts that, that the firm was particularly familiar with. The particular firm that sort of started this trend is not a firm that's super well known in terms of ERISA cases. So I do think there's some interest in being in California. There's been a number of cases filed in California. But if you find a plaintiff and they don't have they don't live in California and the plan doesn't have any, operations in California, then you might file somewhere else. And then I think plaintiffs are really trying to figure out what courts might be in the best position. And unfortunately, this May 24 motion to dismiss, not only was it denied, but the opinion wasn't particularly helpful to plan sponsors and plan fiduciaries. Essentially said, even if the plan terms had been super clear, the court, think that the plaintiffs have a case here, or at least have a chance to go forward. So I think my point in adding to the timeline, kind of the array of courts, is now to say that, this is a trendy complaint, whether it's standalone or added to something else. And just because you don't have operations in California, or have plaintiff participants that could be plaintiffs in California, I think that's no longer any sort of shelter.
Great. Maybe, and if we can get into the size of the plans that are targeted and the asset pools we're talking about here. Sure.
So let's go to the next slide. If you think about it, right, if you bring a case that alleges a fiduciary breach, what the plaintiffs can recover is losses to the plan that result from that breach. And the attorneys can recover some attorney's fees. So the larger the pool of dollars that you're talking about to begin with, the larger the potential loss and then the potential recovery. So, in general, this is a sort of situation where larger plans may well be targeted more directly. And truthfully, many of you probably know this, the forfeitures that can be used to offset employer contributions really generally represent a very small fraction of the dollars that employers contribute to plans. So in the 20 plus cases that have been filed, the smallest plan was 200 million. The largest plan was over $20 billion, and most were $1 billion and above, right? So large plans. The annual contributions ranged, of course, from $10 million to more than $1 billion. And then the annual forfeitures that were used to offset, at least allegedly, contributions were on the low end of 87,000 and the high end of 12 million. So if you just sort of say, well, gee, if my annual contributions are over $1 billion and I just so happen to have $10 million in forfeitures, that's still a really small fraction, right? It's a kind of a drop in the bucket of the overall employer contributions. And one of the things that I think employers get, understandably frustrated about is to say, wait a minute, I put in, 500 million, $1 billion into this plan as matching or contributions to my employees, and I'm getting sued over, using $1 million in forfeitures on an annual basis to offset that contribution. You can see how people are kind of frustrated by that. At the same time, we have sort of a 6-year statute of limitations, right? So if you call it even $1 million a year, that's a $6 million complaint, which is, not nothing. It's a lot to you and me, but but is something that I think is the plaintiff's firms. It really is a business, right? They've decided this is something that is sort of worth their time. So I think that the sort of general theme here is that the larger the plan and the more forfeitures, potentially the more risk there might be.
Great. So maybe just get into the details on what they're trying to challenge here in the court, in the litigation.
Sure. Yeah. So let's talk about that. At a high level, these complaints generally allege a few different violations of the statute. The first is that plan fiduciaries breached their fiduciary duties of loyalty and prudence. ERISA requires that plan fiduciaries, act under a very high standard of care and with utmost loyalty to plan participants. And in that situation, essentially the complaint said, look, when you, plan fiduciary, take forfeitures that are plan assets in the plan's trust account, and you use them or allow the employer to use them to offset contributions, you're really acting for the employer, right? You're not meeting your duty of loyalty to plan participants. Not only that, but a prudent fiduciary wouldn't use plan assets in that particular way. A prudent fiduciary would use forfeiture assets to offset participant, plan expenses, or even allocate to participant accounts. So that's one set of allegations, and essentially the anti-inurement allegations are sort of the same thing, which is, look, the law says that plan assets can't be used to benefit an employer, but if you use forfeitures to offset an employer contribution, the employer gets to keep that money in their pocket. They don't have to contribute it to the plan. So that is a violation of the anti-inurement provision. And then finally, that what you've done is essentially cause the plan to engage in a couple different kind of prohibited transactions. You've used money of the plan for the benefit of the plan sponsor. You've essentially transferred plan money to the sponsor. And so, those are the big allegations. And then, of course, there's a number of themes on the defense side about, what it is that the defendants think happened. And that really, we can go on to the next slide, but those really are around, look, there's no sort of 404 duty to always sort of put your thumb on the scale for participants. If we use employer contributions to offset plan expense, if we use forfeitures to offset employer contributions, ultimately participants are getting exactly what they bargained for. And the defense arguments often have to look at, well, what do the plan terms say? So one of the key issues is, did the plan terms permit or require the use of forfeitures to offset employer contributions? I suspect if many of you go and look at your plan document, it will say something about, when forfeitures happen, what the vesting requirements are, and then it will have something about plan expenses and something about how forfeitures can be used. And a pretty standard type of plan term is that forfeitures may be used to offset employer contributions or for any other permissible purpose, including the payment of plan expenses. And so, one thing to think about is, what are the plan terms? And often the defendants say, well, look, we followed the plan terms. The plan terms are permissive, and there's no violation because we followed the plan terms, just because you don't like the decision that we made. And then, another set of issues involves what kind of process was documented around the decisions about how to use forfeitures. And we'll talk about this a little bit more later on, but I think this is one of those things where, while I certainly don't agree that these are sort of well-founded allegations, I think it is fair to say that often the process that is used around forfeitures and plan expenses more generally is perhaps less, it's a little in the background, right? It sort of depends on a kind of an almost imagined conversation where the plan administrator says to the employer, hey, there's money in the plan that could be used as a legal matter to offset employer contributions, and the plan terms allow that. What would you like to do? And the imaginary conversation back from the plan sponsor is, oh, yes, we would like to use this money to offset contributions. But there's not a lot of documentation around that. And so it can be hard to show sort of a reasoned decision-making process around the use of forfeitures because, people are moving very quickly and there's a lot going on. And often these are not materially financial decisions to the company. And then, is there some sort of plaintiffs can allege, gee, defendants didn't really consider whether participants would be better off if we, use forfeitures for one thing or another. So those are really the issues that participants, that the plaintiffs bring up. Did you follow the plan terms? The plan terms were permissive. Then you had a fiduciary decision to make. Did you have a reasoned decision-making process? Did you document why you made the decision you made? And did you even consider what would be better for participants? And, again, this is one of those things where this has never been an issue until a year ago. So it can be difficult for people for defendants to say, oh yeah, here's the meeting minutes that discuss this, or here's my policies and procedures. And so these are some of the reasons why some of these cases are surviving the motions to dismiss that have been filed. But there are a number of key defenses that have been employed in these cases that have been quite successful, or somewhat successful in some of the cases. So we can go to the next slide and talk about the key defenses. Helpful. So there is the policy argument, right? We talked about, wait a minute, forfeitures really are a special category of plan assets. The IRS says they're a special category. They clearly can be used to offset employer contributions. Participants would get a windfall if you can't say to employers, you're allowed to have a vesting schedule, you're allowed to forfeit certain assets, and the tax code says you can use those forfeitures for certain things, but somehow without the DOL or other courts ever having told plan fiduciaries, you're now supposed to say, oh wait, we can't use this money for the things that the Internal Revenue Code says it can be used for. So the policy argument and the sort of windfall argument, participants get exactly what they're supposed to get. They pay exactly the expenses that they're allowed to pay under the law, and the employer has the ability to decide to use these forfeitures in this way. The other arguments include, look, there's no violation of the anti-annulment provision because every participant is told exactly what the rules are. Here's when you vest, here's when, here's what you get. And so participants get what they're supposed to get. The employer doesn't get any special special treatment here because they only get to use these contributions, these monies they've put into the plan. They're just moving them from one participant account to another participant account. It's not like they get to put the money in their pocket. As to the prohibited transaction rules, there really just is an argument that says a small incidental benefit to the employer doesn't make a prohibited transaction, or even that there really wasn't a transaction here. This is just a contribution, not something that would rise to the level of a prohibited transaction. And then finally, there have been some arguments that say this isn't even a fiduciary decision. This is a settlor decision. This is something that the sponsor decides, that the sponsor has the ability to say, what if the sponsor didn't say anything? They just put in the contributions minus the dollar amount of forfeitures. There was no decision at all. It was just, here's the contribution amount, and the rest of the required contribution comes from the forfeitures. So it really is a settlor act, not a fiduciary act. And then finally, people have made sort of the regulatory and legislative history arguments to say there's no reason to think that Congress, that the IRS, or the DOL ever thought that you could have a fiduciary obligation to use forfeitures in some particular way. So let's see how these complaints and defenses are sort of faring. So far, it's sort of 2-2, right? We've got 2 cases where, again, there have been 20 cases filed, but they're in various sort of stages of working through the courts. So when a motion to dismiss is granted, that means the defense was able to convince the court that even taking all the sort of factual allegations as true, it still doesn't result in a violation of the law. So the motion to dismiss for the HP case was granted, but then often plaintiffs they have what's called leave to amend. They can amend their complaint to see if they can allege, with more specificity, and have a better luck next time. So that case hasn't really gone away. The BAE case actually was dismissed with prejudice, which means that complaint is gone. And in that case, there was some very strong sort of plan language that said you're really required to first use forfeitures to offset employer contributions. And I think that was a pretty helpful fact in that case. And then there are two other cases where the motion to dismiss has been denied. And I realize now that I pasted the wrong case in here, but one of them was Qualcomm and one of them is Intuit, not HP. So the Qualcomm case was the very first one to decide, and the Intuit case was somewhat later. And so their courts have said, no, we're not going to grant this motion to dismiss. This case can go forward to discovery. And whether that leads to a settlement or to trial, we'll have to see. And then of these other, the 16 other cases that are working their way through the courts, virtually everyone, there's been a motion to dismiss filed. So we will continue to see more decisions.
Jenny, quick question. You talked about larger plans, how forfeitures can be a small drop in the bucket into what their match obligation is. Obviously, match is a largely voluntary practice by the sponsor. The fact that a forfeiture might fund a match maybe for a smaller plan or might make a big portion of that contribution, couldn't you argue that it's in the benefit of the participants because there might not be a match if it wasn't funded with forfeitures? Is that something that's been brought forward, or is that too early to make that argument?
No, I mean, absolutely. Those are very much arguments that people are making. And, we have even back to like we have a voluntary pension system in this country, right? You are not required to have a plan. If you have a plan, it has to have certain features and meet certain requirements in order to be tax qualified, so that there is a tax benefit to participants and a tax benefit to employees, as well as sort of other benefits of attracting and retaining folks. So very much, the sort of ultimate, answer would be to eliminate the match, to not even have a plan, or to not have a vesting requirement, right? But there are lots of reasons why employers, they want to incent employees to stick around. They want to incent employees to save their own money for retirement, and a match is a really proven way to do that well. So, I think this is a case where there is very much a tension between this kind of legal theory, which is sort of, participants have to get, every possible benefit from any asset in the trust. We've come up with all kinds of comparison examples, right? Like, sometimes employers will essentially loan money to the plan by paying plan expenses and then seeking reimbursement. And there's an exemption that allows that to happen. There's a very straightforward way of doing that, because plans don't always have the cash on hand, or they don't want to liquidate investments to be able to pay costs. So sometimes the employer will pay and then they'll seek reimbursement. You could say, well, under the theories of these cases, the employer could, pay an expense and then seek reimbursement. Would the plan fiduciaries have an obligation to say, nope, sorry, these are plan assets and I can't possibly pay you back this loan, because that would be a benefit to you and not a benefit to participants? Or plans, they incur costs. They hire managers and lawyers and consultants. And, do you have a fiduciary obligation just not to pay the bills? That can't be the answer, right? Plans engage in all kinds of, need services, have to engage in transactions, and sometimes, there's just not a smooth way of paying expenses. So, I think there's a lot of sort of, this is a slippery slope kind of arguments out there for sure.
Great. So I think we covered the cases. Now I think we'll get to the punchline of what sponsors can do to kind of enhance their practices around forfeiture accounts.
Yeah. And here, I kind of I do want to emphasize, and we can go on to the next slide, that I wish that there were a one size fits all, and I absolutely think there are some things that plan sponsors and fiduciary committees and those who support them can do to make sure that to make ourselves sort of as hard a target as possible, and to improve practices in some ways. And so we can go through some considerations that involve plan language and other things, but I do want to emphasize that every plan is a little bit different. Every, the relationship between the fiduciaries and the sponsor is a little bit different. But we touched on this. I mean, you can't have a cutback, but if you were sort of creating a plan from the beginning, would you could certainly eliminate any vesting requirement, and then you wouldn't have this problem going forward. If you don't have a match, you don't maybe have to put one in. So there are some sort of bottom line things you could do, but most of us have ongoing plans and that sort of thing. So outside of like a real significant change, what can you do in terms of plan language? And I do think there are some things you can do. Again, some of the cases that have been decided, at least on motion to dismiss, have really focused on the plan language. If the plan language says, forfeitures shall be used, must be used to offset employer contributions, that is a pretty strong statement. And then a plan fiduciary would have to determine, if I follow the terms of the plan, I should be protected unless doing so would be a violation of ERISA, at the get-go. And the Qualcomm case kind of said that, but the other cases really have not. And the BAE decision is a good example of that. So you could amend your plan to limit or eliminate discretion over how forfeitures are used. And that would be helpful going forward. Remember, we're dealing with a 6-year statute of limitations, so you just have to be realistic about whether that's helpful. It's not particularly helpful going back. And at the same time, there are sort of potential questions that could be raised in litigation. Well, gee, you changed your plan terms. That must mean there was a problem with the plan terms that you used to have. The other thing is you could say, well, look, it's just a drop in the bucket in terms of match. So let's just say plan forfeitures have to be used to pay plan expenses. You could do that. And then you would sort of just, set the rules. And then, that would be that. The kind of concerns that I've heard with doing that are not so much around the money. I think some employers are sort of offended. Wait a minute, I put this money in, people didn't vest, and now I can't use it for contributions. It's not like I'm trying to put it in my pocket. I'm just trying to use it for what the tax code says I can use it for. But if you can get past that and you'd rather be happy than right, then you could change your plan to say, we're just going to use this money for plan expenses, or we're going to allocate it to participant accounts. But you do have to recognize that you can't keep forfeitures hanging around unallocated in your plan forever, right? So you might be in a situation where, you don't have plan expenses yet. They're going to come in next quarter, but you really have to allocate the unallocated forfeitures, by the end of the year or the first quarter. And so you might end up in a situation where you would have had forfeitures, but you had to allocate them to participant accounts. And now you can't you have to find some other source for paying plan expenses. So there can be some choppiness that people worry about in those sort of fixes. And so those are kind of the implications of some of these decisions. And it really depends on, what are your priorities? Are you trying to do everything you can to avoid a lawsuit, at least prospectively? Then you might want to hardwire some plan terms in, but you have to be able to live with those consequences. And many of our plan sponsors would prefer to have more flexibility, but that does leave you, at least in the near term, until we sort of see how these cases are going to play out, with some greater level of exposure.
Great. So any other considerations before we get to the wrap up? I think you touched on some of these, but.
Oh yeah, a couple that I wanted to mention. So we talked about the statute of limitations, which is generally 6 years. I do think there's some things that people can do in terms of plan expense policies and procedures, right? Really writing down, right? It is a fiduciary decision to decide whether to use plan assets for any purpose, right? But certainly to pay plan expenses. And so, having a set of policies and procedures around what expenses are going to be paid from the plan, or really more, what is the policy or what is the procedure for documenting doing that? So I think, it's something that probably most plan clients of ours, I'm sort of recommending, like, either dust them off if you have them, or let's think about creating some, because I think those can be helpful, especially, just for everybody to know what the expectations are. That sort of conversation that I talked about between the plan sponsor and the plan fiduciary, what do you want to do? Here's what we're going to do. We're not going to put in any more money other than what we have to in contributions, plus what's available in forfeitures needs to be used there. That can be documented. And then another thing, one of the ways that plaintiffs' firms identify plans and then try to find plan participants to be named plaintiffs is by combing through the Form 5500s and particularly the financial statements that are attached to the Form 5500s that are filed by large plans, right? You have to have an audit, and the audit has to have financial statements. If you have employer stock, and you have to file, with the SEC in June, you have to get your financials in early. Lots of times the narrative descriptions in the financial statements will talk about how forfeitures are used. It might just be worth a conversation with the auditors. Do we have to put that in here, right? Does that have to be included as a narrative statement in the financials? If the auditors say it's a rule, fine. But I think for the most part, it's a permissive requirement. They need to look at whatever they need to look at to issue the opinion, but how they describe what the plan says or what the practices are, that sometimes just carries over year to year. So a small thing you might be able to do is have a conversation with your auditor to say, what is required to be in the narrative that goes along with the opinion and the financial statements, and what is sort of, extra that we don't need to put in there, because we don't really need the plaintiffs' firms to have more information than they already have.
Well, that's a great tip, and I think a good mark to go out on. Wanted to just thank Jenny for her insight here. We went about 45 minutes plus, so that's way more than I imagined I could do on forfeiture accounts. So thank you for making that conversation engaging. For you all, thank you all for joining. Please feel free to reach out to your consultant if you need any more information. Again, we have slides for you all to download, and have a great rest of your Tuesday.
Yeah, thanks all. Thanks, Dan.